how do we even begin to make sense of the incredibly complex tapestry of global issues, especially, when human rights are right there at the center?
Hmm.
We constantly hear terms like international law, maybe human rights law, but what are they really?
Yeah.
Where did they actually come from? And perhaps the big question, how do they operate in the messy real world?
That's the fundamental question, isn't it?
Yeah,
We're navigating a world where borders seem less defined by geography sometimes and more by these complex layers of rules and relationships.
right.
And it's so different from the laws within your own country where you usually have a clear government, a clear authority. International law works in a really different way.
Exactly. And that difference is absolutely key, I think, to understanding its strengths and, well, its limitations too.
For sure.
Welcome, everyone, to the Deep Dive. Our mission, as always, is to take a stack of source material, the research, the articles, the notes, and really pull out the most important nuggets of knowledge and insight. We want to give you that shortcut to being genuinely well-informed, cutting through the complexity, hopefully with some surprising facts and enough engaging conversation to keep you hooked. And we should mention, much of the material underpinning today's discussion comes from resources made available by the University of London, which is fantastic for students digging into this area.
Absolutely.
Yeah.
Think of us as guides, maybe, helping you see the landscape of the material and understand which pieces are, well, most vital to really grasp.
We also want to mention this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
And on that note, good luck to all of you preparing for exams. We hope this helps.
Definitely.
Okay, so today we're undertaking a deep dive into that fascinating, sometimes, let's be honest, frustrating world of international law, with a particular focus on its absolutely crucial relationship to human rights. It feels incredibly relevant right now, doesn't it, given everything we see happening around the globe? It really does. And we're going to unpack the deep history of this legal system, because you just can't understand where it is today without knowing where it came from.
Right. History matters here.
Yeah. We'll get to grips with what international law is at its core, explore its fundamental sources, like where do the rules actually come from?
Okay.
We'll see how this big international framework connects, or sometimes doesn't connect, with the law right where you live within your own country.
That connection is key.
And we'll take a really close look at one single foundational document that everyone talks about, the Universal Declaration of Human Rights. The UDHR.
UDHR, right. So why is this deep dive so important for you listening?
Well, because understanding international law, and especially human rights law, is really key to grasping the frameworks that are intended to protect individuals globally.
Intended being the operative word sometimes.
Exactly. It helps us see the often daunting challenges they face. The difficulties in actual enforcement, the undeniable power imbalances between states.
Which are huge. Huge. And how different countries grapple with applying these vital concepts. It is complex. It can feel counterintuitive sometimes, but it's absolutely essential, I think, for navigating and understanding the world we live in today.
And as you said, we're drawing our insights today from those materials made available, offering a pretty comprehensive look at this crucial area of law. Our goal really is to help you identify the fundamental sources of international law.
Okay.
Understand that relationship between international and domestic law.
That monism mergilism thing we'll get into.
Right, and see clearly how international human rights law fits into that bigger, sometimes messy picture.
Okay, let's jump in. You mentioned history first. Where does this whole idea of law between nations really begin?
Well, the concept itself, it's ancient. Really ancient. It's inherent in the very idea of organized human societies having to interact with each other.
Right. If you have groups, they interact, they need rules.
Exactly. When we say international, we literally mean international law that applies between these distinct political entities, whether we call them nations, states, empires, tribes.
And this interaction isn't new at all. Ancient city-states needing trade routes, empires setting boundaries, tribes negotiating alliances, or, well, going to war. They all needed some agreed-upon rules for engagement.
Absolutely. Necessity really was the mother of invention here. If you wanted safe passage for your merchants, let's say, or a way to send a message during a conflict without your envoy being killed,
You needed rules.
you needed established norms. And that's why diplomatic relations rules about how envoys are treated, how communication happens, they're among the oldest rules of international law we can actually trace back.
And rules about war itself.
Yes, rules regulating conflict are also incredibly ancient. trying to limit its brutality, maybe establishing norms for surrender, things like that.
And these earliest rules, they weren't written down in big treaties necessarily. They just emerged.
Precisely. This takes us straight to the oldest source of international law, what we call customary international law.
Customary law.
Those very early rules were simply norms reflecting the actual consistent practices of these political entities. They did certain things, or they refrained from doing others, maybe, as a historical example, not killing children or priests during a conflict.
Okay.
And over time, this consistent practice wasn't just seen as, a habit or a courtesy. It became perceived as obligatory.
Ah, the belief part.
Exactly. The entities following the rule came to believe they were legally bound to do so. That belief, what lawyers call opinio juris, is absolutely key. Practice plus belief.
So that's the deep ancient root. When does it start looking more like the system we kind of recognize today with states and things?
Well, the big marker everyone points to is usually the Treaty of Westphalia, 1648.
Right, end of the 30 Years' War in Europe.
Yes, but it was more than just ending a war. It fundamentally restructured the European political order. It really moved away from this idea of an overarching religious authority like the papacy or the Holy Roman Empire having the final say.
And instead,
It solidified the concept of the sovereign state.
sovereign meaning, independent, in charge of its own territory.
Yes, exactly.
Yeah.
Independent with supreme authority over its own territory and internal affairs. And critically, these sovereign states were treated, at least in legal theory, as formally equal units.
Formally equal, even if one was tiny and one was huge.
Right. On paper, equal standing. Each state was responsible for what happened inside its borders, and the principle emerged a really important one, that other states shouldn't interfere in those internal affairs. Non-intervention.
Okay.
And this system, based on independent, formally equal states needing to interact and cooperate, that's really the bedrock of modern international law. It kind of arose out of the chaos of religious wars and the need for a stable way for these new entities to coexist.
In this system, born in Europe, naturally it reflected European ideas and values initially.
It absolutely did. Our source material notes, for instance, the influence of the idea of a res publica Christiana, a sort of Christian commonwealth, in its early formation. But then, as European powers expanded globally through colonization,
They took this model with them.
they effectively universalized this model of statehood, imposing it across the globe, which of course forced the system itself to evolve and adapt, often quite slowly and painfully.
The Congress of Vienna, 1814-15, is mentioned as a key transition point. After Napoleon shook everything up.
Yes, after the Napoleonic Wars, the major European powers tried to create a new, stable order. This period saw a definite move towards a more secular, more legalistic system, trying to base it on principles like neutrality and objectivity, stepping further away from those explicitly religious frameworks.
Moving towards recognizing independent political communities regardless of religion.
Towards that idea, yes. Even if the application was, well, discriminatory for a long time. It was a shift towards a system that could, theoretically, encompass non-Christian states too, moving away from the Christian Commonwealth towards a system of legally equal independent communities.
And the pace of change just exploded in the last century or so.
Dramatically, especially in the last, say, 75 years plus. International law has expanded massively in scope, in the number of actors involved, all driven by globalization, incredible advances in technology, and just vastly increased contact and interdependence between states and other actors.
You can see that with technology. The source mentions the Universal Postal Union way back in 1874, just to handle international mail.
Right. A basic necessity requires international rules.
Then telegraphs, telephones, aircraft. You can't just fly your plane into another country without agreements.
Absolutely not.
And now, of course, the internet, all
Yeah.
demanding international regulation.
Exactly. And the actors involved have diversified hugely. While states are still the primary subjects, international law increasingly recognizes and has to regulate entities beyond states.
Like international organizations.
Yes, think about the sheer number and influence of them now. The UN itself, the World Trade Organization, WTO, the European Union, EU, the World Bank, the IMF. These are major players. There's been a real proliferation of these bodies.
And the number of states themselves has ballooned. Decolonization in the mid-20th century was huge for that.
Absolutely. The UN membership is a really stark indicator. It's roughly quadrupled since 1945. And to be a member, you generally have to be recognized as a state. So that growth directly reflects the changing state system itself.
In recent history, recent events continue to shape and, frankly, challenge international law, don't they?
Constantly, the legacy of those anti-colonial struggles, the ideological battles of the Cold War, their effects are still felt. And even though the Cold War ended, removing one massive source of tension, older issues didn't disappear, and plenty of new ones have emerged.
The source uses Syria, the conflict there since 2011, as a really sharp contemporary example. It shows how all these different elements just collide.
It's a tragic illustration. You've got fundamentally differing state interests, Russia versus Western powers, regional actors all involved.
You have powerful non-state actors, like extremist groups operating across borders.
Exactly. You have fundamental questions about the use of force between states, intervention, sovereignty.
And massive, horrific human rights issues right at the center.
Yes, international law provides the framework, imperfect as it often is, to try and navigate this kind of incredibly complex, dangerous situation.
This complexity, this feeling that the rules aren't always followed, sometimes leads people to say international law is in crisis.
You hear that a lot. But the source material offers a really important perspective here. It suggests that normative change in international law, the evolution of the rules, often happens precisely because of crisis.
So crisis drives change. It doesn't necessarily mean the system is broken.
That's the argument. These difficult situations highlight gaps or weaknesses or ambiguities in the existing rules, and that prompts adaptation and evolution. That's quite different from saying the entire discipline, the whole system, is collapsing or is irrelevant.
So it's a system under pressure, constantly adapting, rather than a system failing.
That's a good way to put it. Now, the source does mention counter-arguments like Goldsmith and Posner's book, The Limits of International Law, which basically argues international law is mostly just a reflection of state power and national interest, not a real constraint.
A more skeptical view.
A very skeptical view. But the material we're drawing on frames that as provocative, maybe, but perhaps not fully capturing the whole picture. The system's reacting and changing, yes, but its ability to shape state behavior, to set standards, to provide a basis for claims and condemnation that shouldn't be dismissed lightly.
Okay, that gives us the historical sweep and the sense of constant evolution. Now, let's really try to pin down what is international law at its core. How is it fundamentally different from the law, say, governing traffic or contracts in my own country?
Okay, the fundamental nature. As we touched on, the key distinction is often described as horizontal versus vertical.
Right. Domestic law, the law inside your country that's vertical, you've got a government, a parliament or legislature, courts, police. It's a hierarchy. The state is clearly superior to individuals and companies within its borders.
And the state generally has the power to make laws and, crucially, enforce them upon its subjects.
Okay. International law, then, is horizontal.
Primarily, yes. It exists between states, and those states are, as we said, formally equal in their sovereignty.
Even though we know in reality power differences are enormous.
Of course. But the legal framework itself is built on this idea of equal standing, equal sovereignty.
And this horizontal structure, it leads directly to the other core characteristic you mentioned earlier.
Oh.
It's overwhelmingly consensual.
Yes. This is fundamental. States are generally bound only by rules they have, in some way, agreed to be bound by. They choose to sign and ratify treaties. They participate in practices over time that develop into customary law because they accept that practice as legally required.
Consent is key.
Consent is absolutely key, though it's really vital to flag, even now, those important exceptions we have to come back to. Just cogents, those peremptory norms and obligations, erga omnes.
Right, the ones that might bind states even without explicit consent.
They aren't based entirely on that traditional model of individual state consent, let's put it that way. They represent something more fundamental. We'll unpack that.
Okay. But generally, consensual and horizontal, and that has huge implications for enforcement, right? You said no world police force.
Exactly. There's no international police ready to swoop in and arrest a state leader or enforce a judgment globally. Our source suggests a better domestic analogy might actually be civil law, like contract law or tort law. Well, if someone breaks a contract they made with you, the police usually don't get involved. You might sue them in court, get a judgment saying they owe you money.
But actually getting the money if they refuse to pay can be a whole other battle.
Right. Enforcement can be a separate challenge. It relies on different mechanisms. International law is a bit like that, but on a much grander, more political scale.
We do have an international court system, though, the ICJ.
We do. The International Court of Justice, the ICJ, based in The Hague in the Netherlands. It's the principal judicial organ of the United Nations, established by the UN Charter itself. Its statute, its rulebook, is actually part of the charter.
And what does it do?
It hears legal disputes between states. That's its main contentious jurisdiction. It can also issue advisory opinions on legal questions, but only when asked by certain authorized UN bodies, like the General Assembly or the Security Council.
Okay, disputes between states. But, and this seems like the really big, but its jurisdiction, its power to hear a case, depends on consent.
Absolutely, fundamentally based on consent. A state cannot be forced to appear before the ICJ unless it has previously agreed somehow to let the court have jurisdiction over that type of issue or over disputes with that particular state.
So states have to opt in to the court's power.
Essentially, yes. Through various means agreeing in a treaty that disputes under that treaty go to the ICJ, making a general declaration accepting the court's jurisdiction or agreeing specifically for a particular case. Without that prior consent, the court has no power over them.
And even if the court does hear a case and issues a judgment, you said enforcement is tricky.
It can be. The judgments are legally binding on the parties involved in the case. Article 59 of the ICJ statute says that. And Article 94 of the UN Charter says the Security Council can take measures to give effect to an ICJ judgment if a state fails to comply.
Can. Sounds like there's wiggle room.
There is, and this is where raw politics, realpolitik comes in. Our source points out, if the state ignoring the judgment is one of the 5 permanent members of the Security Council, China, France, Russia, UK, US, or a close ally of one,
They can use their veto power.
they could use their veto to block any Security Council action aimed at enforcing the judgment against them or their friends. It makes compelling compliance politically very, very difficult, sometimes practically impossible. The more powerful the state, generally, the harder it is for the system to force its hand.
That sounds like a major weakness.
It is a significant limitation, no doubt. But it's important to keep perspective. While high-profile cases of non-compliance get all the attention, states do generally comply with the vast majority of ICJ judgments.
Really?
Yes, there are reputational costs to ignoring the World Court. Diplomatic pressure, internal pressure sometimes. The system isn't perfect, its limits are clear in highly politicized cases, but it does have a degree of effectiveness most of the time.
Okay, so that's the basic framework. Horizontal, consensual enforcement challenges. Now, where does this law actually come from? Let's get into the sources.
Right, the sources. The traditional starting point, the place everyone refers to, is Article 38, Paragraph 1 of the Statute of the ICJ.
That's the court's own rulebook again.
Exactly.
Yeah.
It lists the sources the court itself is supposed to apply when deciding disputes. Now, it's maybe not perfectly exhaustive of all possible sources of international law, but it's the standard accepted list.
Okay, what's on the list?
First, at 38.1a, we have international conventions, whether general or particular, establishing rules expressly recognized by the contesting states.
Conventions. Basically, treaties.
Yes, treaties, agreements, protocols, any written agreement where states expressly agree to certain rules.
Okay, then.
Next, 38.1b, international custom, described as evidence of a general practice accepted as law.
That's the older source you mentioned, arising from what states do and believe.
Precisely.
Yeah.
State practice plus opinio juris.
Got it, the third.
38.1c, the general principles of law recognized by civilized nations.
Civilized nations. That phrasing sounds a bit dated.
It does reflect the time it was drafted, but it's generally understood today to mean principles common to the major legal systems of the world.
Okay, and finally.
38.1 lists subsidiary means for the determination of rules of law, specifically judicial decisions and the teachings of the most highly qualified publicists of the various nations.
Subsidiary means, so not sources of law themselves, but ways to figure out what the law is.
Exactly. They help interpret or evidence the rules found in treaties, custom, or general principles. They're tools, not primary sources.
And you said this list might not be totally complete.
Well, most scholars agree it's the main framework, but other things can sometimes create obligations or influence the law. For example, unilateral acts of states, like a formal public promise made by a head of state, can sometimes create binding obligations.
Okay.
And certain decisions of international organizations might also be seen as sources, although often they can be understood as flowing from the treaties that created those organizations anyway.
And what about this idea of soft law? You hear that term, especially in areas like human rights or environmental law.
Yes, soft law. It's a useful concept, even if the name sounds a bit contradictory.
Because law is supposed to be hard, binding.
Right. That's the debate around the term. But soft law is generally used to describe instruments that aren't formally legally binding in the way a treaty is, but they still have significant influence on state behavior and legal development.
Like what sort of things?
Could be treaties with very vague aspirational language, more like goals than concrete obligations. Could be non-binding resolutions, say, from the UN General Assembly. Codes of conduct adopted by international bodies. Reports or declarations by expert groups or eminent lawyers.
So states don't have to follow them legally.
Not in the sense of facing legal sanction for breach of a treaty obligation. But states often pay close attention to them. They can provide political guidance, reflect an emerging consensus, shape expectations.
And maybe they can become hard law later.
Exactly. Our source suggests they can act as sort of embryonic norms. If states start consistently acting in line with the soft law principle and develop the necessary opinio juris, that principle might eventually crystallize into a binding rule of customary international law. So they're part of that dynamic evolutionary process.
Okay, interesting. Let's dive deeper into the main sources now, starting with treaties, Article 38(1).
Right, treaties. Or international conventions. It's fascinating because the law about treaties, how you make them, interpret them, terminate them, is itself largely found in a major treaty. The 1969 Vienna Convention on the Law of Treaties, the VCLT.
Ah, a treaty about treaties.
Exactly. It really shows how international law is this self-referential system sometimes. The VCLT is binding as a treaty for the states that are party to it.
But parts of it are also considered custom.
Yes. Many of its core rules, like how treaties are interpreted or the rules on material breach, are widely considered to reflect customary international law. So they bind even states that haven't formally ratified the VCLT itself. It shows that overlap between sources again.
And the absolute core principle for treaties, reinforcing what you said earlier, a state is only bound if it consents.
Absolutely fundamental. A state must consent to be bound by a treaty, typically through signature followed by ratification or accession. If it hasn't done that, the treaty generally doesn't create legal obligations for it. Consent remains king.
Now, for human rights specifically, treaties are massively important. There are so many key ones.
Hugely important. They form the bedrock of modern international human rights law. Our source lists some of the major global ones we really need to know. The 1948 Convention on the Prevention and Punishment of the Crime of the Genocide Convention.
Crucial.
The 1965 International Convention on the Elimination of All Forms of Racial Discrimination, or CERD.
Okay.
Then the two big ones from 1966, often called the Twin Covenants, the International Covenant on Civil and Political Rights,
ICCR,
and the International Covenant on Economic, Social, and Cultural Rights,
ICCR. Got it.
These translate many of the ideals of the UDHR into binding treaty form. Then you have the 1979 Convention on the Elimination of All Forms of Discrimination Against Women.
CEDAW, right.
The 1984 Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, CAT. The 1989 UN Convention on the Rights of the Child, CRC. The 2006 UN Convention on the Rights of Persons with Disabilities, CRPD. These are huge multilateral treaties.
And also things like the Statute of the International Criminal Court.
Yes, the Rome Statute, which defines crimes like genocide, crimes against humanity, war crimes. And we absolutely have to mention the Geneva Conventions of 1949 and their additional protocols, which govern international humanitarian law, the law of armed conflict. Hugely relevant to human rights in wartime.
And there are regional treaties, too.
Very important ones, like the European Convention on Human Rights, the African Charter on Human and People's Rights, the American Convention on Human Rights. These create strong regional systems for human rights protection. There are many, many human rights treaties.
So technically, what actually counts as a treaty under international law? What's the definition?
The VCLT, in Article 2.1a, gives us the standard definition. It defines a treaty as an international agreement concluded between states in written form and governed by international law.
Okay, let's break that down. International agreement.
Meaning the states intend to create legally binding obligations between themselves under international law. It's not just a political statement.
Concluded between states.
The VCLT primarily covers agreements between states. International law also governs agreements involving international organizations, but the VCLT focuses on state-to-state treaties.
In written form.
Oral agreements between states can be legally binding under international law, but the VCLT rules specifically apply only to written ones. Most important agreements are written down.
And governed by international law.
This distinguishes treaties from, say, purely commercial contracts between a state and a foreign company, which might be governed by a specific national law. The parties intend for their agreement to operate within the international legal system.
Okay, makes sense. And treaties can be just between two states.
Bilateral treaties, yes.
Or involve many states.
Multilateral treaties, like most of the big human rights conventions.
Now, you mentioned the overlap between treaties and customary law. Can you elaborate on that relationship? It seems complex.
It is complex and very dynamic. They constantly interact. As we noted, the same obligation, like, say, the prohibition of torture, can exist simultaneously in both treaty law, like the CAT, and customary international law.
So a state could be bound by both at the same time.
Absolutely. Or it might only be bound by the customary rule if it hasn't ratified the specific treaty.
And drafting a treaty can help clarify what a customary rule actually means.
Yes, that's a key function. The negotiation process forces states to agree on specific wording. This can crystallize or make more precise a rule of custom that might have been a bit vague or debated before. The treaty provides clear textual evidence.
And can treaties push the law forward, maybe create new rules that aren't yet custom?
Definitely. A treaty might include provisions that are quite progressive, going beyond what most states currently practice or accept as binding custom. This is often called progressive development of the law.
And then custom might catch up later.
Exactly. If states start consistently acting in accordance with that progressive treaty provision and develop the necessary opinio juris, then over time, that treaty rule can actually pass into customary international law, binding even states not party to the original treaty. Treaties can be catalysts for customary law development.
What if there's a conflict? Say a treaty rule seems to clash with a customary rule. Is there a hierarchy? Which one wins?
Good question. There isn't a strict formal hierarchy like in some domestic systems. Generally, between the same states, the rule that is later in time, lex posterior, might prevail over an earlier one. Also, a more specific rule, lex fatalis, might prevail over a more general one in a particular situation. Or sometimes the general rule prevails over the specific one. It depends very much on the context and the intent. It's about interpretation. Except.
I sense just cogents coming back.
You sense correctly. This is the one clear instance of hierarchy. As we mentioned when defining treaties, Articles 53 and 64 of the VCLT deal with just cogents, or peremptory norms of general international law.
Remind us what Article 53 says.
Article 53 states that a treaty is void, completely invalid from the start if, at the time it's concluded, it conflicts with a peremptory norm of general international law, a just cogents norm.
Void, like it never legally existed.
Exactly. No legal effect whatsoever. And Article 64 adds that if a new peremptory norm emerges after a treaty has been concluded, any existing treaty which conflicts with that new norm becomes void and terminates.
Wow. So these just cogents norms are truly superior to treaties.
Yes. They are normatively superior.
Yeah.
They represent fundamental overriding obligations accepted by the international community of states as a whole as norms from which no derogation is permitted. You simply cannot contract out of them via a treaty.
What are examples? We mentioned slavery.
Prohibition of slavery, prohibition of genocide, prohibition of torture, prohibition of aggression, prohibition of racial discrimination, piracy. These are generally accepted examples. They reflect fundamental values of the international community.
So if two states somehow made a treaty tomorrow agreeing to commit genocide against a group,
that treaty would be absolutely void under Article 53 VCLT. It would have no legal standing whatsoever because it conflicts with the just cogents prohibition of genocide.
Okay, that makes the power of just cogents very clear. Now, sticking with treaties and consent, states don't always agree with every single part of a multilateral treaty, do they? How do they handle that?
That leads us to reservations. Reservations are another really important feature reflecting the consensual nature of international law, and frankly, the practical need for flexibility in a world with nearly 200 diverse states.
What exactly is a reservation?
The VCLT Article 21D defines it. It's a unilateral statement, however phrased or named, made by a state when signing, ratifying, accepting, approving, or acceding to a treaty.
Okay, when joining.
Yes, whereby it purports to exclude or modify the legal effect of certain provisions of the treaty in their application to that state.
So basically, a state says, okay, I'll join this treaty, but Article 10 won't apply to me, or Article 15 will only apply to me in this modified way.
That's the gist of it.
Yeah.
It's trying to tailor its specific obligations under the treaty. Now, the old traditional rule on reservations was incredibly strict.
How so?
It basically required unanimity. Every single other state party to the treaty had to accept your reservation for it to be valid.
That sounds impossible for modern treaties with hundreds of parties.
Totally impractical.
Yeah.
Imagine trying to get universal agreement on every reservation to a major human rights treaty today. It would make multilateral lawmaking virtually impossible. The lowest common denominator would be incredibly low, or treaties would never enter into force. and new states joining later would face huge hurdles.
So the approach had to change.
It had to become more flexible. A really pivotal moment was an ICJ advisory opinion back in 1951 concerning reservations to the Genocide Convention. The Cold War was starting, decolonization was on the horizon, the UN was new. The court adopted a more flexible, pragmatic approach.
And this flexible approach is now what's in the VCLT.
Yes, it's codified, essentially, in Article 19 of the VCLT. It basically says a state can formulate a reservation when joining a treaty, unless
There are exceptions.
three main ones. A, the reservation is explicitly prohibited by the treaty itself. Some treaties say no reservations allowed.
Okay.
B, the treaty provides that only specified reservations may be made, and the one the state is trying to make isn't on that specified list.
Right.
Or C, and this is the really important and often tricky one, the reservation is incompatible with the object and purpose of the treaty.
Incompatible with the object and purpose, that sounds like a judgment call. Who decides that?
Exactly. That's the huge challenge, particularly in human rights law. What constitutes incompatibility? If a state makes a reservation to a core, non-derogable right in a human rights treaty, is that incompatible? Other states can object to a reservation on these grounds, but disputes arise. It's a real area of legal debate and difficulty.
So it's a flexible system, but with this important safeguard, even if it's hard to apply sometimes.
Yes. Trying to balance getting wide participation in treaties with maintaining the integrity of the treaty's core goals. And underlying all treaty law, including reservations, is the fundamental principle of pacta sunt servanda. Agreements must be kept, and the obligation to perform treaties in good faith.
Okay, that covers treaties and reservations really well. Let's switch back now to the other main source, customary international law. Article 38(1)(b). How do lawyers or courts actually figure out if a rule is custom? It sounds less clear-cut than a written treaty.
It definitely can be. As Professor Brierley famously put it, customary law is something more than mere habit or usage. It is a usage felt by those who follow it to be an obligatory one.
So not just something states happen to do, but something they do because they feel legally bound to.
Exactly. You need those two essential elements we keep coming back to, reflected in Article 38(1)(b's definition. First, evidence of a general practice. That's the state practice element, what states actually do.
State practice.
Then second, that practice must be accepted as law. That's the subjective element, the opinio juris necessitatis, the belief that the practice is legally obligatory.
Practice plus belief. Opinio juris.
Both are necessary. You can't have custom without state practice, and you can't have it just from practice without the belief that the practice is required by law.
You mentioned a kind of paradox here earlier. How can a practice become law if states have to believe it's already law for their practice to count towards creating it?
It's a classic conceptual puzzle in international law. In reality, the two elements are deeply intertwined and often develop together. You often infer the opinio juris, the belief, from the nature and consistency of the practice itself and from what states say about their practice. It's not always a strict chronological sequence.
So, practically speaking, when an international lawyer or a court is trying to determine if a customary rule exists on a certain issue, what questions do they have to ask?
They face several key questions. How widespread and consistent does a state practice need to be? Does it have to involve all states or just a significant majority? How long does the practice need to have existed? Can custom form quickly, or does it require decades or centuries?
Okay. Duration and consistency.
Whose practice matters most? Is the practice of powerful states more influential? Or states particularly affected by the rule in question? What actually counts as evidence of state practice? Is it just physical actions or also diplomatic statements, national laws, court decisions?
Lots of evidence types.
And crucially, the tricky one. How do you prove the existence of opinio juris? How do you show states are acting out of a sense of legal obligation and not just out of courtesy or political expediency or habit? And when did that belief crystallize into law?
It sounds quite challenging to pin down definitively.
It can be. As Judge Tanaka noted in a dissenting opinion in the famous North Sea Continental Shelf case back in 1969, determining custom isn't an exact science. The time required, the extent of practice, it's all relative. Formation is an organic and dynamic process.
But the ICJ has given some guidance, right, in the majority judgment of that same North Sea Continental Shelf case.
Yes, that case is foundational for understanding custom. In paragraph 74 of the judgment, the court made several key points about state practice. First, the passage of only a short period of time isn't necessarily a bar to forming custom, if the practice during that time has been sufficiently widespread and uniform.
So custom can form quickly sometimes.
Potentially, yes,
Sure.
especially if the need is urgent and state practice is clear and consistent. But the courts stress the practice must be extensive and virtually uniform. This implies broad participation by states and a high degree of consistency in their actions. Minor inconsistencies might not defeat a rule, but widespread variation would.
And the court also said something about whose practice matters most.
Yes, it emphasized that the practice of states, whose interests are specifically affected by the potential rule, is particularly important.
Give an example.
Well, for rules about maritime boundaries or rights at sea, the practice of major maritime powers and coastal states would carry particular weight. For rules about outer space, the practice of spacefaring nations would be crucial. Their actions and statements are especially relevant.
Okay, that makes sense. Now, how do you prove that really difficult element, the opinio juris, the belief that the practice is legally required? How do you get inside the mind of a state?
You can't directly.
Yeah.
So you have to infer it from evidence. What kind of evidence? Well, often the same evidence used for state practice, but interpreted differently. Public statements by government officials, diplomats, ministers, arguments made by states before international courts or tribunals, national legislation that reflects a certain rule, voting patterns on UN resolutions. Critically, how states react to the actions of other states.
Reactions are key.
Very key. Protests against another state's action can be strong evidence that the protesting state believes a legal rule has been violated. Acquiescence or silence in the face of a practice might, over time, be interpreted as acceptance of its legality.
The Nicaragua case from 1986 is famous for illustrating this point about reactions, isn't it? The U.S. support for Contras against the Nicaraguan government.
Exactly. The ICJ looked at alleged breaches of the customary rule prohibiting the use of force. The court made a crucial statement about consistency in opinio juris. It said that for a customary rule to exist, state conduct doesn't have to be in perfect, rigorous conformity with the rule.
Okay.
What matters, the court said, is that conduct should be generally consistent with the rule. And crucially, instances of state conduct inconsistent with the rule should generally have been treated by other states as breaches of that rule, not as indications of the recognition of a new rule.
Ah. So if a state breaks the rule and other states say, hey, you broke the rule, that actually reinforces the existence of the rule.
Precisely. It confirms their opinio juris, their belief that the rule exists and is binding. If instead, states just accept the inconsistent conduct without protest or start acting inconsistently themselves, that could signal that the old rule is weakening or a new competing rule is emerging.
So it's a constant process of assertion, action, reaction.
Absolutely.
Yeah.
And the court acknowledged that there can be transitional periods where you might have two competing customary rules vying for dominance until one eventually prevails.
This discussion about UN resolutions and voting patterns brings up a point we touched on earlier, but it bears repeating because it's often misunderstood. What is the legal status of UN General Assembly resolutions? Can they create customary law?
This is such a critical point and often a source of confusion for students. The bottom line, as our source material stresses very clearly, UN General Assembly GA resolutions are, as a general rule, not formally legally binding in themselves.
Not binding, even if they're called declarations.
The name doesn't change the fundamental legal status. Instruments like declarations or resolutions adopted by the GA do not inherently create binding legal obligations on member states just by virtue of being adopted.
So passing a GA resolution doesn't automatically create custom?
No, absolutely not. However, and this is the important nuance, some GA resolutions, particularly those adopted by consensus or near unanimously, and which express legal principles or purport to declare existing law, can play a significant role in the process of developing or identifying customary rules.
How? What role can they play?
They can serve as important evidence. Evidence of state practice, the act of voting for the resolution, sponsoring it, making statements about it, and, perhaps more importantly, evidence of opinio juris.
Evidence that states believe the principles in the resolution reflect binding law.
Yes, or that they accept them as principles that should become binding law. A strong, consistent pattern of GA resolutions affirming a certain principle, coupled with consistent state practice outside the UN, can be powerful evidence that the principle has become customary law. But, and this is crucial, you cannot generalize.
Each resolution needs to be looked at carefully.
Exactly. You have to examine the specific wording of the resolution. Is it aspirational, or does it sound like it's stating law? The circumstances of its adoption, was it unanimous, contentious? The statements made by states during negotiation of voting, and most importantly, subsequent state practice. Does state behavior actually conform to the resolution's principles? You absolutely cannot just say the GA passed a resolution, therefore it's custom. It's much more complex evidence gathering.
Okay, that distinction is vital. Let's move to the third source listed in Article 38, General Principles of Law. What exactly falls under this category?
This source, Article 38(1)(c), the general principles of law recognized by civilized nations, is perhaps the most abstract and debated of the main sources.
And again, that civilized nations phrasing.
Yes, it's archaic language.
Mm.
Today, it's universally understood to mean principles that are widely recognized in the domestic legal systems of states around the world across different legal traditions, common law, civil law, etc.
So principles taken from national law and applied internationally.
That's one major understanding. As Judge Amount suggested in the North Sea case, they can be procedural or substantive norms common to different national legal systems that are then transposed or adapted for use in the international legal system.
Examples.
Things like principles of procedural fairness, the right to be heard, alterum partem, principles against bias, or substantive principles like the concept of good faith, or the principle that you can't benefit from your own wrong, or rules about evidence, or the concept of estoppel, where you can't go back on a previous representation if someone relied on it.
In Professor Crawford's description mentioned in the source, he included things like consent, reciprocity, equality of states.
Yes, that highlights another aspect. Some see general principles as also encompassing fundamental principles inherent to the international legal system itself, not necessarily derived directly from domestic law. Principles like the sovereign equality of states, or pacta sunt servanda, agreements must be kept, or the principle of good faith in international relations. It's a diverse category.
Does the ICJ use these principles often? Does it explicitly say, I'm applying a general principle under 38(1)(c)?
The ICJ certainly relies on principles like good faith, equity within the law, and procedural fairness quite frequently in its reasoning. However, it often doesn't explicitly label them as coming specifically from Article 38(1)(c). They're often just woven into the legal reasoning as fundamental legal concepts. So it's an accepted source, but perhaps less frequently cited explicitly than treaties or custom.
Okay. Now, for the last category in Article 38(1), the subsidiary means judicial decisions and the teachings of jurists. Remind us why they're subsidiary.
Subsidiary means they are not sources of law in themselves. Unlike treaties or custom, they don't create international law. Article 38(1)(d) says they are subsidiary means for the determination of rules of law.
So they help us find or understand the law that comes from the other sources?
Exactly. They are tools for interpretation and evidence.
How do judicial decisions, say from the ICJ or other courts, help determine the law if they aren't a source themselves? Doesn't the ICJ make law when it decides a case?
Technically, no. Article 59 of the ICJ statute explicitly states that the decision of the court has no binding force except between the parties and in respect to that particular case. There's no formal doctrine of precedent, stare decisis, like in common law systems, where lower courts are bound by higher court rulings.
So an ICJ judgment only legally binds the states involved in that specific case.
Correct. However, in practice, ICJ judgments are treated with immense respect and carry huge authority. The court naturally strives for consistency in its own jurisprudence, and its interpretations of treaties or determinations of customary rules are highly influential for states, other tribunals, and scholars.
So they help clarify and develop the content of the law.
Absolutely. Decisions of international courts and tribunals, ICJ, regional human rights courts like the European Court of Human Rights, international criminal tribunals, and sometimes even significant decisions of supreme national courts dealing with international law issues all contribute to understanding what the law is or how it applies in certain situations. They provide evidence of the state of the law.
This seems particularly relevant for human rights law, given the number of different bodies interpreting similar rights.
Immensely important. The case law, the jurisprudence coming out of bodies like the UN Human Rights Committee, interpreting the ICCPR, the European Court of Human Rights, the Inter-American Court of Human Rights. It's absolutely vital for understanding the detailed meaning and scope of human rights obligations under those treaties.
And you mentioned ICJ advisory opinions earlier. They aren't legally binding at all, right?
Correct. They are advisory, not judgments in contentious cases. But again, they carry enormous weight as interpretations of law by the UN's principal judicial organ.
And the source listed several really influential ones.
Yes, key opinions that have significantly shaped international law. The reparation for injuries case, 1949, was fundamental for establishing the legal personality of international organizations like the UN itself. The Genocide Convention opinion, 1951, on reservations, which we discussed, the Nuclear Weapons opinion, 1996, grappling with the legality of nuclear weapons, the construction of a wall opinion, 2003-04, concerning Israel's barrier in occupied Palestinian territory, and the more recent Chagos Archipelago opinion, 2019, on decolonization and self-determination. These advisory opinions, though not binding in a formal sense, have been incredibly influential in developing substantive international law.
Okay. What about the other subsidiary means? The teachings of highly qualified publicists, writings of legal scholars.
Yes, Article 38(1)d includes teachings of the most highly qualified publicists of the various nations. Again, like judicial decisions, these are subsidiary means tools to help determine the law, not sources of law themselves.
How useful are they in practice? Do courts actually cite Professor X or Professor Y?
The ICJ itself rarely cites individual academic writers directly in its judgments these days, although it might have done more in the past. However, the work of leading scholars is undoubtedly influential in shaping legal thinking, identifying emerging trends, critiquing state practice, and proposing interpretations.
So it's more of an indirect influence?
Often, yes. But there's one body whose work is frequently cited by the ICJ and is incredibly important: the International Law Commission, the ILC.
Ah, the ILC. You mentioned it before. It's composed of legal experts.
Yes, it's a body of 34 eminent international law experts, elected by the UN General Assembly, representing the world's major legal systems. Their mandate is the progressive development and codification of international law.
Codification meaning writing down existing customary law.
Yes, clarifying and systematizing existing rules. And progressive development means proposing new rules where the law is unclear or needs updating.
And their work is highly respected.
Extremely. The ILC produces draft articles, reports, and commentaries on major topics like the law of treaties, which led to the VCLT, state responsibility, diplomatic protection, and many others. While these drafts aren't automatically binding law themselves, unless states adopt them as a treaty, the ICJ and other courts frequently refer to the ILC's work as authoritative evidence of the state of customary law, or as influential guidance. So the teachings of publicists are very important, especially through the collective, highly regarded work of the ILC.
Right, that makes sense. Now, Article 38 has one last little provision, doesn't it? Article 38(2), about deciding a case ex aequo et bono. What's that about?
Yes, Article 38(2). It's an interesting one. It says that the list of sources in paragraph 1 doesn't prejudice the power of the court to decide a case ex aequo et bono, which basically means according to what is fair and just in the specific circumstances, if the parties agree thereto.
Only if the parties...
Yes, that's the crucial condition. The states involved in the dispute must explicitly agree to allow the court to decide based on fairness, rather than strictly applying the existing rules of law.
How is that different from using the principle of equity? Doesn't the court sometimes talk about equity?
That's a key distinction. Equity, as the ICJ explained in the Fisheries Jurisdiction case, 1974, is generally applied infra legem, meaning within the law. It's about using principles of fairness to interpret or apply the existing legal rules in an equitable way to reach a fair outcome derived from the applicable law.
Okay, so equity works with the law.
Yes. Deciding ex aequo et bono, however, would potentially allow the court to go contra legem against the law, or praeter legem beyond the law. It could disregard existing legal rules if fairness seemed to demand a different outcome. It's a much broader, almost legislative power.
Has the ICJ ever actually used this power? Have parties ever agreed to it?
No. To date, the parties in a case before the ICJ have never agreed to allow the court to decide ex aequo et bono. So Article 38(2) remains a theoretical possibility, not something that's been put into practice.
Fascinating. Okay, let's circle back one more time to those really important, somewhat unique concepts we flagged. Jus cogens and erga omnes. We've established jus cogens are these superior peremptory norms that void conflicting treaties. What else defines them again?
To really hammer it home, jus cogens norms are normatively superior. They represent fundamental overriding obligations.
Yeah.
They cannot be limited or suspended even by treaty or custom unless modified by a subsequent norm of the same character, which is very rare. They apply universally to all states. They reflect fundamental values accepted by the international community as a whole as non-derogable. And yes, their key operational effect via VCLT Articles 53 and 64 is to void conflicting treaties or acts.
Got it. Superior, non-derogable, fundamental values. Now, obligations, erga omnes. You said they are distinct but related.
Yes, distinct but often overlapping concept. Obligations, erga omnes, are obligations owed by every state towards the international community as a whole.
Oh, to everyone.
Essentially, yes. The key idea, first articulated by the ICJ in a famous passage, a dictum, technically, in the Barcelona traction case in 1970, is that because these obligations are owed to the community as a whole, all states have a legal interest in their protection.
A legal interest, meaning any state could potentially complain if another state breaches an erga omnes obligation, even if they aren't directly injured.
That's the implication, yes. It relates to standing or the right to invoke responsibility. For ordinary international obligations arising from, say, a bilateral treaty, only the state directly harmed by a breach typically has standing to complain. But for erga omnes obligations, the idea is that the breach harms the interests of the entire community, so potentially any state could have a legal interest in ensuring compliance.
What examples did the court give in Barcelona traction?
The court specifically mentioned the outlawing of acts of aggression and of genocide, and it also referred to the principles and rules concerning the basic rights of the human person, including protection from slavery and racial discrimination.
So core human rights are included there.
Absolutely. While the full scope of erga omnes obligations is still debated, it's now widely accepted that rules of basic international humanitarian law and the prohibition of torture also have this character. Many just cogents norms also give rise to erga omnes obligations. They protect fundamental community interests. But the concepts are distinct. Just cogents is about the hierarchy and non-derogability of the norm itself, while erga omnes is about the scope of application and the legal interest of all states in its enforcement.
Does the existence of these categories, just cogents and erga omnes, imply a sort of hierarchy within human rights themselves? That some rights are more fundamental than others?
Yes, it certainly does. The idea that certain rights, like freedom from torture, slavery, or genocide, represent just cogents norms and give rise to erga omnes obligations, clearly signals that these are considered more fundamental, more non-negotiable than perhaps some other rights which might be subject to limitations or derogation in emergencies. This hierarchy is often reflected within human rights treaties themselves, which might designate certain rights as non-derogable.
And thinking about consent again, how did states consent to these erga omnes obligations that apparently bind everyone? Do they all sign something saying we accept these are owed to everyone?
Not explicitly in that way. It wasn't like states voted on the concept of erga omnes. Rather, the ICJ in Barcelona Traction identified this category based on the existing clear evidence of universal state acceptance of the underlying prohibitions. The prohibitions on aggression, genocide, slavery, racial discrimination.
So states had already accepted the rules themselves as fundamental.
Yes, through treaties, widespread customary practice, universal condemnation. The erga omnes characterization by the court was a recognition of the fundamental importance and universal applicability of these already existing norms, reflecting the collective interest in their observance. States might violate them in practice, tragically, but no state today seriously argues that genocide or slavery are legally permissible. The norm itself is universally accepted.
Okay, that clarifies the relationship between consent and these universal obligations. We've covered the sources thoroughly now. Let's move to that crucial link. How does all this international law, especially human rights law, actually connect with the law inside a country, domestic law?
This is absolutely critical because, as we said, human rights are experienced and often violated at the domestic level. How international law is received, how it's applied, whether it can be directly used in national courts, that's all determined by the domestic legal system of each individual state. International law itself doesn't dictate how states must implement it internally, only that they must comply with their international obligations.
And there are different ways states structure this relationship. The traditional models are monism and dualism.
Exactly. These are the two classic theoretical approaches, though in reality, most states probably fall somewhere on a spectrum between the pure forms. It's a way of conceptualizing the relationship.
Okay, what's the monist view?
A monist approach sees international law and domestic law as part of one single unified legal order. International law is considered inherently part of the domestic system. Once a state accepts an international rule, like ratifying a treaty, it automatically becomes part of that state's internal law, potentially without needing any further legislative action.
So, in a purely monist system, a citizen could potentially go to their local court and argue a case based directly on an international treaty the country has ratified.
In principle, yes, particularly if the treaty provision is considered self-executing, clear and precise enough to be applied directly by a court without further legislation. The Netherlands is often given as a classic example of a relatively monist system, where international law can often have direct effect domestically and even prevail over conflicting national law.
Okay, one unified system. What's the dualist view?
Dualism sees international law and domestic law as two separate, distinct legal systems. They operate on different planes. International law governs the relations between states on the international level. Domestic law governs the relations between individuals and between individuals and the state within the country.
Separate bubbles?
Essentially, yes. In a pure dualist system, international law has no automatic effect within the domestic legal order. For an international rule, like a treaty provision, to become enforceable in domestic courts, it needs to be deliberately transformed or incorporated into domestic law through an act of the national legislature.
So Parliament or Congress has to pass a specific law that essentially copies the treaty's rules into national law.
Exactly. The United Kingdom is a classic example of a predominantly dualist state. Treaties ratified by the UK government do not automatically become part of UK law. Parliament must pass an Act of Parliament to give them domestic legal effect.
So if I'm in the UK, I can't just walk into court waving a UN treaty. I need to point to a specific UK law, like the Human Rights Act 1998, which incorporated parts of the European Convention.
Precisely. You argue based on the domestic statute, the Act of Parliament. And our source highlights this very clearly with a statement from Lord Hoffman in the UK House of Lords case R.V. Lyons back in 2003.
What did he say?
He stated very bluntly that international treaties ratified by the UK do not form part of English law unless incorporated by legislation. English courts have no jurisdiction to interpret or apply unincorporated treaties directly. If Parliament does pass a statute that mirrors the treaty's terms, it is the statute, not the treaty itself, that is the source of law applied by the English courts.
That seems very clear-cut. Separate systems.
It is. And he added another important point. English courts are generally not bound by the interpretations of an international treaty given by an international court, like, say, the European Court of Human Rights, even if the UK is bound by that interpretation on the international plane, unless the UK statute explicitly tells the courts to follow those interpretations.
Wow. So even if an international court says a treaty means X, a UK court applying a UK law based on that treaty might say it means Y.
Theoretically, yes, although UK courts generally try very hard to follow the jurisprudence of relevant international bodies, especially the European Court of Human Rights, when interpreting the Human Rights Act. But the ultimate source of authority for the UK court is the Act of Parliament, not the international treaty or court directly.
This really highlights the challenges for individuals trying to enforce international human rights domestically in a dualist system.
It does. However, there's a mitigating principle, even in dualist systems like the UK. Lord Hoffman also mentioned in Lyon that there's a strong practical presumption in English law. Courts will presume that Parliament intends to legislate in conformity with the UK's international obligations.
Meaning
Meaning that when interpreting an ambiguous UK statute or developing the common law, courts will strive to adopt an interpretation that avoids putting the UK in breach of its international commitments, including human rights treaties it has ratified.
So they try to read domestic law in a way that fits with international law, even if they can't apply the international law directly.
Exactly. It's a principle of harmonious interpretation. It shows a desire to align the two systems, even while maintaining their formal separation. But the key takeaway is that the relationship between international and domestic law varies significantly, and you need to understand a specific country's constitutional approach, monist, dualist, or hybrid, to know how international human rights norms can be invoked domestically.
Okay, that clarifies the domestic connection. Now let's zoom in on one specific, incredibly influential document we mentioned earlier, the Universal Declaration of Human Rights, the UDHR. Adopted by the UN General Assembly in 1948.
Yes, the UDHR, a cornerstone document. And the central question that always comes up, which has evolved over time, is about its legal status. Was it legally binding then? Is it now?
It had high aspirations. Eleanor Roosevelt, who chaired the drafting committee, famously called it potentially the International Magna Carta for all men everywhere, comparing it to foundational national documents like the Magna Carta or the Bill of Rights.
High hopes indeed. Let's quickly walk through its structure, as outlined in the source, because the content is key to understanding its impact and eventual legal significance.
Okay. It starts with broad principles.
Yes, Article 1 lays down those core philosophical foundations. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. Very aspirational, connecting human dignity to inherent qualities.
Article 2 then establishes equality and non-discrimination.
Crucially, yes. Everyone is entitled to the rights in the Declaration without distinction of any kind. Race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. This applies to the enjoyment of all the human rights listed.
Article 3 is called the first cornerstone.
Yes, the right to life, liberty, and security of person. Absolutely fundamental, the prerequisites for enjoying almost any other right.
Then comes a big block of rights, Articles 4 through 21. These are generally the civil and political rights.
That's right. A really comprehensive list for its time. It includes freedom from slavery and servitude, Art 4. Freedom from torture or cruel, inhuman or degrading treatment or punishment, Art 5. Recognition as a person before the law, Art 6. Equality before the law and equal protection, Art 7. The right to an effective remedy for violations, Art 8. Freedom from arbitrary arrest, detention, or exile, Art 9. The right to a fair and public hearing by an independent tribunal, Art 10. Presumption of innocence, Art 11. Right to privacy, family, home correspondence, Art 12. Freedom of movement within borders and the right to leave and return to one's country, Art 13. Right to seek asylum, Art 14. Right to a nationality, Art 15. Right to marry and found a family, Art 16. Right to own property, Art 17. Freedom of thought, conscience, and religion, Art 18. Freedom of opinion and expression, Art 19. Freedom of peaceful assembly and association, Art 20. And the right to take part in government, directly or through chosen representatives, and access to public service, Art 21.
Wow, that's a huge sweep of civil and political freedoms.
It really is. Then, Article 22 acts as a bridge, the second cornerstone, introducing the economic, social, and cultural dimension. It speaks of the right to Social Security and the realization of economic, social, and cultural rights indispensable for dignity and free development.
And Articles 23 through 27 detail those rights.
Yes. The right to work, free choice of employment, just conditions, protection against unemployment, Art 23. Right to equal pay for equal work, Art 23. Right to rest and leisure, including reasonable limitation of working hours and paid holidays, Art 24. Right to a standard of living adequate for health and well-being, including food, clothing, housing, medical care, social services, Art 25. Right to education, Art 26. Right to participate freely in the cultural life of the community, Art 27.
These sound different in character from the civil and political rights.
They're often seen as requiring more active state provision, linked to resources. The Declaration itself notes they're intended for realization through national effort and international cooperation, dependent on the organization and resources of each state. But they are presented as equally essential for human dignity.
And the Declaration finishes by talking about duties and limitations.
Absolutely crucial point. Articles 28 to 30 make it clear rights don't exist in a vacuum. Article 28 speaks of an entitlement to a social and international order where these rights can be realized. Article 29 stresses that everyone has duties to the community. It also says that limitations on rights must be determined by law, solely for the purpose of securing recognition and respect for the rights of others and meeting the just requirements of morality, public order, and the general welfare in a democratic society.
So limitations are allowed, but only under strict conditions.
Yes, and crucially, rights cannot be exercised contrary to the purposes and principles of the United Nations. And Article 30 provides a vital safeguard. Nothing in the Declaration can be interpreted as implying for any state, group, or person any right to engage in any activity aimed at the destruction of any of the rights and freedoms set forth within it. You can't use human rights language to destroy human rights.
Okay, a powerful and comprehensive statement. But back to that key question. Its legal value in 1948. Was it binding law then?
According to our source material, the overwhelming consensus at the time among the drafters and observers was quite clearly no. It was not intended to be legally binding.
Why not?
It was deliberately drafted and adopted as a General Assembly resolution, as a declaration of principles, precisely because states could not agree on making it a legally binding treaty at that point. There were too many disagreements, particularly between the emerging Cold War blocs and concerning colonial territories.
So it was meant as a statement of common aspiration, a standard to aim for.
Exactly. The intention was that it would set the common standard, the principles, which would then be elaborated upon and translated into legally binding form later through the drafting of specific treaties.
Which is what eventually happened with the ICCPR and ICSCR in 1966.
Yes, but notice how long that took from 1948 to 1966. Nearly 2 decades of complex and often contentious negotiations were needed to turn the UDHR's principles into binding treaty obligations for the states that ratified them. That delay itself shows there wasn't agreement on binding status in 1948.
Okay, so not intended as binding, but could you argue that maybe it was already reflecting binding customary international law back in 1948? That it was just writing down existing custom?
Our source material considers that argument far-fetched for 1948.
Why far-fetched?
Several reasons. First, only 48 states voted in favor, with 8 abstentions and 2 absence. That's hardly representative of the entire global community even then. Second, many of the states that did vote for it were, frankly, acting in ways that directly contradicted its core principles. Like the major colonial powers maintaining vast empires denying self-determination and equality, or the United States with racial segregation still legally entrenched, or the Soviet bloc with its severe restrictions on civil and political liberties. Their vote in favor of the aspirational declaration could hardly be taken as credible evidence that they accepted all its principles as already binding customary law upon them. Their practice spoke louder than their vote on the declaration.
Okay, so not binding as a treaty and not reflecting binding custom in 1948. What is the modern understanding of its legal status? Has it changed?
Yes, significantly. The prevailing view today, supported by the source material, is that while the UDHR's provisions were not customary law in 1948, its adoption was the start of a crucial process.
A process of norm development.
Exactly. Over the decades since 1948, through the constant repetition and affirmation of its principles in countless other international declarations, resolutions, treaties like the covenants, national constitutions, judicial decisions, through this consistent state practice and demonstrated opinio juris, many, though perhaps not absolutely all, of the rights set out in the UDHR are now considered to represent binding customary international law.
So it acted as a catalyst, helping these rights crystallize into custom over time.
Precisely. It had immense moral authority and became a common reference point. Over time, state practice aligned with many of its principles, and the belief grew that these principles were indeed legally binding. Think of the prohibition of torture or slavery or systematic racial discrimination. These are now undoubtedly rules of customary international law, binding on all states, regardless of treaty ratification, and the UDHR played a major role in that crystallization process.
But it didn't codify all existing custom even in 1948.
No. For example, the fundamental right of self-determination, which was certainly an emerging principle then, strongly pushed by newly independent states, isn't explicitly listed as a numbered right in the UDHR, though hinted at. This shows the UDHR wasn't simply a snapshot of all custom in 1948. Its real importance lies in its forward-looking influence, its role as a common standard of achievement that gradually transformed into binding custom for many of its core provisions.
Okay, that's a much clearer picture of its evolving legal weight. Now, if these rights, whether from treaties or custom, are violated, what about remedies? Can individuals get remedies?
This brings us back to that complex intersection of international and domestic law and the status of the individual. The answer is, it depends.
Depends on the treaty, on the country.
Both. Some human rights treaties do explicitly require the states that are party to them to provide an effective domestic remedy for breaches of the rights guaranteed in that treaty.
A domestic remedy, meaning I should be able to go to a court in my own country.
Yes. Article 13 of the European Convention on Human Rights is a classic example. Yeah. It guarantees an effective remedy before a national authority for anyone whose convention rights are violated. Article 2.3 of the ICCPR has a similar provision.
And this domestic remedy requirement is in addition to any international mechanisms the treaty might set up, like complaining to a UN committee.
Often, yes. The idea is that remedies should primarily be sought domestically first. International mechanisms are often seen as subsidiary, to be used if domestic remedies are unavailable or ineffective.
But, and this seems crucial, not all treaties require domestic remedies.
Correct. That's a really important point. Not all human rights treaties include an explicit obligation to provide domestic remedies, and some treaties don't even establish any international enforcement or monitoring mechanism at all.
Can you give an example?
The 1951 Refugee Convention, a foundational treaty for protecting refugees, famously lacks both an explicit right to a domestic remedy for breach and any international body to hear complaints or enforce compliance. Enforcement relies heavily on national courts applying the convention, if incorporated, and diplomatic pressure.
But is there a trend towards including these mechanisms in newer treaties?
Yes, our source material notes a discernible trend, particularly in the major global human rights treaties adopted more recently. They do tend to establish some form of enforcement or monitoring body, like a treaty committee that can review state reports or sometimes hear individual complaints. Think of the committees for SIC, CEDAW, CRC, CRPD.
But even if a treaty requires a domestic remedy or sets up an international committee, actually getting a remedy, especially in a domestic court, can still be incredibly difficult.
Absolutely. It depends hugely on that state's specific constitutional setup regarding international law. The whole monism dualism question again. Has the treaty been incorporated into domestic law? If so, how? Is the specific right recognized as part of customary law that the domestic courts can apply? Does the domestic constitution itself protect that right? Can courts review government actions for compliance? It's often a complex legal and procedural maze for individuals. It's certainly not universally guaranteed or straightforward.
This leads us directly to perhaps the most fundamental conceptual challenge for international human rights law: the status of the individual within the international legal system itself.
Yes, this is really the core tension, because traditionally, as we've discussed, international law was conceived as a system governing relations between states.
States were the subjects, the actors with legal personality.
Exactly. International legal personality means having the capacity to possess international rights and duties, and the capacity to bring claims on the international plane to vindicate those rights. The ICJ in the Reparation for Injuries case, 1949, confirmed that states possess the totality of international rights and duties recognized by international law.
And individuals traditionally didn't have that personality?
No, not in the same way. They were generally seen as objects of international law, things the law might protect, like aliens under diplomatic protection rules, rather than subjects with their own standing to bring international claims. Individuals generally have no standing before the ICJ, for example. Only states, and sometimes international organizations for advisory opinions, do.
This creates that fundamental paradox for human rights law, doesn't it?
It really does. You have a system designed to protect the rights of individuals, but it's built upon a legal framework where states are the primary rights holders and duty bearers. And the enforcement mechanisms are designed by states, operated by states, and often depend on the consent of states who are frequently the very entities accused of violating the individual's rights in the first place.
It sounds almost designed to fail sometimes.
It highlights the inherent structural challenges. However, international law has evolved significantly, especially since 1945 and the rise of the human rights movement.
How so?
International law now clearly recognizes that individuals do possess certain international rights, particularly under human rights treaties. And in very specific, limited contexts, individuals do have procedural capacity, standing, to vindicate those rights on the international plane.
Like complaining to the UN Human Rights Committee under the ICCPR's optional protocol, or taking a case to the European Court of Human Rights.
Exactly. Those are prime examples where specific treaties grant individuals limited international standing vis-a-vis their own state.
And individuals also have duties now, not just states. International criminal law.
Yes, that's the flip side of the coin, another major post-1945 development. International law now clearly imposes duties and responsibilities directly on individuals for certain egregious conduct, international crimes like genocide, crimes against humanity, war crimes. Individuals can be held personally accountable before international criminal tribunals, like the ICTY, ICTR, or the Permanent International Criminal Court, ICC.
So the individual is emerging more as a subject, but it's still quite limited and context-specific.
Absolutely. Individual standing exists within these specific frameworks created by treaties, specific human rights treaty bodies, international criminal courts. It's not a general right to sue anyone on the international plane. And the mechanisms themselves are still state-designed, often lack strong enforcement powers, and usually don't provide the same kind of direct enforceable remedies like damages paid promptly that you might theoretically get from a domestic court.
So if we really want to understand how human rights are enforced or protected, we need to look beyond just courts and formal legal remedies.
Precisely. Understanding human rights law in action requires a broader, more political, more nuanced understanding. It involves looking at the role of diplomacy, international pressure, naming and shaming, NGO advocacy, media attention, economic sanctions sometimes, the slow influence of international standards on domestic law reform. It's a much wider picture than just judicial enforcement.
Okay, so let's quickly try to pull the main threads of this whole deep dive together. International law, which is the foundation for international human rights protection, traditionally saw states as the main actors, the primary holders of rights and duties. And that history profoundly influences how human rights law developed and how it functions today.
Right. And the familiar model we have for domestic law, with its clear hierarchy, its legislature, its police force, its courts with compulsory jurisdiction, that model just doesn't map neatly onto the international plane, especially for human rights enforcement. It's a different beast.
And the actual enforcement mechanisms for international human rights are often much broader, more complex, and rely heavily on how international law is received and implemented within domestic legal systems, as well as on all those other political and diplomatic factors, not just court procedures.
We've covered a huge amount today. We trace the history from ancient customs to the Westphalian state system and its modern evolution. We defined international law's core features: horizontal, consensual, its unique enforcement challenges via bodies like the ICJ.
We systematically went through the sources in Article 38.1, treaties, custom, general principles, and the supporting role of judicial decisions and jurists, including the ILC's work. We touched on soft law and really drilled down into the special status of jus cogens and erga omnes obligations.
Then we explored that vital, often complicated relationship between international and domestic law, looking at monism versus dualism, using the UK as a key example of the challenges of domestic application.
And finally, we took that deep dive into the Universal Declaration of Human Rights, its content, its non-binding status in 1948, but its incredible evolution into a document whose core principles are now widely seen as reflecting binding customary international law. We repeated key concepts in cases like North Sea Continental Shelf, Nicaragua, Barcelona Traction, to hopefully help embed them.
Absolutely. And thinking about how human rights issues play out in these different legal settings, domestic law, specific treaties, general international law like custom. Hopefully this discussion has shown how you can start to clarify rights and obligations by identifying the relevant sources and understanding that complex dance between the international and the domestic. The UDHR is just such a prime example of how a document's status and influence can evolve dramatically over time.
It really is. Okay, that brings us towards the end and leaves us, perhaps, with a final thought to chew on. Given everything we've discussed, the consensual nature of international law, the huge power differences between states, the challenge of enforcing human rights when the state is the main subject and often the alleged violator, how effective can international human rights law truly be if it doesn't have strong, accessible, and willing domestic legal systems to back it up?
That's the million-dollar question, isn't it? Or perhaps is its main power less about immediate coercive enforcement and more about the long game? Setting those universal standards, shaping norms and expectations globally, providing the language and framework for advocacy and critique, and slowly, incrementally influencing state behavior and domestic legal reforms over decades. Where does its real power lie?
Something to definitely think about. A huge thank you for guiding us through that complex landscape.
My pleasure. It's a fascinating and vital area. And again, thanks to the University of London for the materials and Sinorbit Academy Sri Lanka for their support. Best of luck to all students.
That's all for this deep dive. Thanks for listening.
Thank you.
See you next time.